Hi, Darin Mangum here, the PPM attorney. Today's video wanted to talk about what is a cease and desist order, or sometimes it's called a C&D or cease and desist. What is it, and what's the impact of it? A cease and desist order is an order or a finding of fact that's issued by a securities regulator. Typically, cease and desist orders, the SEC can issue them as well as states. Each of the states of the United States can issue a cease and desist order. What is it? It's basically, it's like a speeding ticket, basically saying, hey, we believe you've violated the securities laws, basically it's an injunction to say, hey, stop violating the securities laws of our state. And typically they're issued when maybe there was an inadvertent offering, a public offering of securities that were unregistered. And as far as enforcement tools or the enforcement actions, as far as the scope of what they could be, certainly it's not like it's not a criminal proceeding, right? Which is good, right? It's not to that level, and it's also doesn't usually involve like filing. It's not like they're suing you in state or federal court. Usually it's all within the matter of an administrative proceeding. And typically it's issued at the end of an investigation. Now, sometimes the company has notice of the investigation, and other times they're just issued if they find that, let's say you've got somebody that's cold calling investors, and obviously that's a no-no. Especially if you're just under like a federal, like say Rule 506B, it's not allowed, or any limited state offering exemptions, it's not allowed. And so certainly that cease and desist basically would outline, hey, we found these certain facts that you're violating the securities laws, and basically stop doing it. You're ordered not to continue, right? Now, obviously, you do have real bad guys out there that do multiple cease and desist orders that may, let's say they get, it's kind of like a slap on the wrist. Sometimes there's an administrative fine that's associated with it. But if they then continue and sort of ignore the order and just keep doing it anyway, and they don't curb their activity to comply with the securities laws, then obviously, the regulator could ratchet up. Especially the states, they have, unlike the SEC. The SEC is a purely civil regulator. They can't bring criminal actions, whereas the states, they most of the time they're also deputized under the state attorney general's office. And if they feel like you're a perpetual violator, in practice we kind of see that play out as like, hey, one strike, two strikes, okay, maybe we'll increase the fines, and then maybe, hey, three strikes, they'll bring criminal charges, right? And they'll just, ratchet it up. They basically, hey, if you're violating these cease and desist orders, hey, we're gonna try to put you away, basically, right? So they are to be taken seriously. If you ever receive a cease and desist order, or you're getting notice that they're, of an investigation, you definitely want to involve a securities attorney and make sure that you can at least mitigate the damages, right? Ideally, you wouldn't even be there in the first place, but if you find yourself behind the eight ball, you definitely want to engage a securities attorney to help you. Are you able to continue to raise? A question I get a lot is, hey, I got this cease and desist order several years ago, or maybe I had some legal proceedings, I had a bankruptcy, I had some sort of securities infraction years ago. Can I still raise capital? The answer to that is yes, but obviously your options are a little bit more limited in scope. You may be, depending on when it happened, if it happened, after November or after September 23rd of 2013, then certainly you may be excluded as a bad boy or bad actor under like Regulation D. That may no longer be available to you, and so then you're forced to find other exemptions like Section 4A2 at the federal level, and potentially other state exemptions that are limited offering exemptions in those states. And so the answer to the question is yes, you can probably, unless you're actually the cease and desist order, unless it imposed some sort of bar from raising capital, which is pretty rare, but it does happen. But unless that is the case, you can usually continue to raise capital under other exemptions that don't prohibit you a bad actor, and not that you're a bad person. I'm just saying, that's a legal term, bad actor. It's like, hey, you can't, these exemptions are no longer available to you, but especially, and the fact that if it's disclosed in the PPM as, hey, we had this infraction, but obviously we settled it, blah, blah, blah. I mean, that has to be disclosed in a private placement memorandum. So, but yeah, so the answer is yes, you can continue to raise capital if you had this kind of issue in the past. But again, definitely consult with a securities attorney. If you have questions about it, feel free to reach out to me. Glad to help you address it. So anyway, hopefully this content is helpful for you. And if it's so, please like it or subscribe or leave some comments. Or feel free to reach out to me, call us. Be glad to help. Anyway, thanks for watching, and we'll see you on the next video. Thanks.